On this episode of Law Weekly, we talk about the ongoing process of constitution amendment against the background of the just concluded nationwide consultation by the National Assembly on the process. We speak to Senior Advocate of Nigeria, Olanipekun, on the prevailing issues, one of which is whether an amendment will suffice, despite the clamor in some quarters for a brand new constitution. Olanipekun is one of the few senior advocates of Nigeria under the age of 40, and at his elevation in 2018, he was the youngest senior advocate of Nigeria. Bode holds a master's degree in international commercial and maritime law from the University of Wales and is a member of Maritime Arbitrators Association of Nigeria, Chartered Institute of Arbitrators United Kingdom and Nigeria. He has vast experience and has been consistently involved in high-profile litigations on constitutional, electoral, energy, and other matters. He's also been in various specialized non-litigation transactional legal practice and continues to act as counsel and arbitrator for numerous indigenous and foreign firms doing business in Nigeria and across Africa in diverse areas of law. Last week on the show, I showed you some of his submissions before the Southwest Constitution Review public hearing in Lagos. Does he think that the exercise was robust enough? That's the starting point of this conversation. Enjoy.
It's arguable whether it is a step in the right direction or not. Now, will the step that has been taken, will the outcome of the steps being taken reflect the aspirations of Nigerians? Well, I can't tell for now, but the truth of the matter is at every stage in national development, leadership must consult. I see it as some form of consultation. Representations were made to parliamentarians. We can only hope that those representations will be reflected in the outcome of the process. But yes, they got sufficient reactions from Nigerians as to how we want as to what we want in our governing document, which is the Constitution. Yeah, they got sufficient information. I think so.
Okay, so let's talk about the process of constitutional amendment itself. Some commentators have argued that merely amending the Constitution will not solve the challenges, that what we need is a brand new Constitution. Others say a brand new Constitution that makes provision for physical restructuring and devolution of powers. Others believe that an amendment will solve the problem. What do you think?
So, let me start from the position that can hardly be contested, that the preamble to the 1999 Constitution is not 100% true, where the Constitution represents that we, the people of the Federal Republic of Nigeria, have given ourselves this Constitution. Having said that, is the Constitution of Nigeria, the 1999 Constitution of Nigeria today, an operative law? Yes. Does it command compliance? Yes, it does. Against that background, we can then progress to what the provisions are as to whether the process of amendment is legal. Section 9 is clear in the Constitution. It permits an amendment. Now, legally speaking, there are judicial authorities that say that an amendment includes substitution and replacement. Of course, there's also the other side of the argument that can you place something on nothing? Well, again, that's a generalized view that people sort of take to the extreme, because at times you can, something can come out of a process that is not 100% solid. You can still build on it. So, if this amendment process reflects the aspirations of Nigerians, I think it will solve the problems that come up, devolution of power and all of those. Will this amendment process solve the problem? I don't know. Can this amendment process solve the problem? Yes, it can. The proponents for a brand new constitution also have very valid basis of asking for a brand new constitution, and one of the bases is the fact that we, the people of Nigeria, did not give ourselves this constitution. So let's work from a solution or end result point of view, right? If we can achieve what we need is a constitution that addresses how we as Nigerians are governed, that addresses how the various nationalities that comprise Nigeria, how we coexist together. So if we identify what we want and an amendment can give us what we want,
why not?
Why not? If it's a new constitution that will give us what we want, why not? But what we should not lose sight of is what exactly do we want
to achieve.
Mm-hmm. And I think honestly that if the National Assembly is willing to go the whole log, an amendment can achieve it if it addresses the many aspirations of Nigerians.
Yeah, I want to take a cue from one of the things that you said about governance, we the people. Now, we're aware of IPOB and groups that want to go their separate ways. So how confident, or what do you think, how can we address the issues of people like that who don't even believe in the Nigeria, who want to secede and stay on their own, IPOB and all of those groups, in the making of a constitution? As you've said, this process can give us a new constitution if that is what we desire, because there is a provision for it in the constitution already.
So, thank you. You see, let's appreciate that some things led to these agitations by these various groups. So, they have grievances. Now, are they going about their grievances the right way?
Debatable.
It's debatable, right? So what a constitution making or a constitution review process will do is would allow a sit down with all these groups, right? What are your grievances? How will those grievances be addressed, right? And look, let's face it, what exactly do these separatist groups want? They want greater control of power at the local levels. So they want governance closer to the people. I honestly think that asking for devolution of powers is a legitimate demand, right? If the center sheds off, quite a number of load in terms of, again, items, for instance, on the exclusive legislative list. I think if quite a number of those powers are devolved to the constituent units, these agitations would actually reduce if they don't vanish altogether. I think so.
And the time has come for the center to shed some of this weight.
Oh, no doubt about it. No doubt about it. I don't think I've heard any convincing argument why the center should not shed those powers. In any event, what we're seeing in Nigeria today is proof that we cannot continue to be governed, or we cannot continue to coexist as a people in the way we have been coexisting. Should we continue as a people together? I think so, but we need to sit down and discuss how we will continue to coexist. And the conversation is, request for a conversation is legitimate. It is certainly legitimate.
Let's come to the judiciary. One of the positions you took when you appeared at one of the sessions was that the number of appeals should not be limited to the Supreme Court because of quality and lack of confidence in rulings and judgments coming from the lower courts. Can you expatiate on that?
So, I believe in litigants having the right to ventilate their grievances up until the highest level. That's my own philosophical bent. Now, should the jurisdiction of the Supreme Court continue as it is forever? Arguably, no. Is this the right time for us as a country to reduce the jurisdiction, the appellate jurisdiction of the Supreme Court? I don't think so. And I'll try to be scientific about this, or I think that the approach should be scientific. There was a time the Court of Appeal, for instance, was the final appellate court for governorship election disputes. The National Assembly changed that situation and now reverted to what was before, under the 1979 Constitution, to the Supreme Court being the final appellate court. Now, there were reasons why the National Assembly took this step. So, let's go to the answer of the National Assembly as to what informed that decision. So, what mischief was the National Assembly trying to cure? Now, has that mischief been cured to necessitate a reversal to that status quo? If that mischief has been cured, fine. So if you are saying that, well, what made us, if the National Assembly is saying that what made us change the status quo or the pre-existing status quo is also now manifesting, so let us, for that reason, just go back, and the problem has still not been solved. The problem still remains. So for me, I don't think we've gotten to that point yet where the jurisdiction of the Supreme Court should be reduced. When we get to that point where judicial outcomes are trusted and respected by the generality of the populace, then we can reduce the jurisdiction of the Supreme Court. But as at now, when quite a number of people are still disenchanted with judicial outcomes, I believe that people should be allowed the maximum opportunities to ventilate their grievances.
Because I'm thinking, if it is about outcome and the fact that people don't trust judicial outcome, would it matter if it stops at the Court of Appeal or it goes all the way to the Supreme Court? People are still not going to trust the system anyways. And then we have a situation where we say that the courts are very clogged. So taking all the cases all the way to the Supreme Court is not helping the situation.
So, you see, that exactly is my point. Why don't people trust judicial outcomes? Right? Is it because cases go all the way to the Supreme Court? That's not the reason. Right? It's not because cases go all the way to the Supreme Court that people don't trust or, sort of respect judicial outcomes in certain circumstances. So, reducing the jurisdiction of the Supreme Court will not solve that problem.
But the same argument could also be made that if you reverse the status quo, it still doesn't change anything.
Yes, so let's address the reason why judicial outcomes might not be trusted.
How do we address it?
So, one, the appointments procedure, and quite a number of lawyers, the NBA has been canvassing for a review of the appointment procedure so that the important considerations will be merit, character, competence. So, when you have a system that those are the prevailing considerations, you certainly would, judicial outcomes certainly will be trusted. And let's face it, as of today, not all cases go to the Supreme Court anyway. you can again introduce the process of leave to appeal. So put in stringent conditions to allow a full ventilation to the Supreme Court, so that so you just don't curtail the right altogether. You can put sort of a stopgap, that is stringent conditions for applications for leave to appeal.